Let's start. The appeal is directed against the judgment and order dated 09/04/1990 passed by Landed Judge Special Court within bracket EC Act MALDA in Special Court case number 13/88 convicting the appellant for commission of offence punishable under section 7 within bracket 1 within bracket small a within bracket small ii of the Essential Commodities Act 1955 for violation of para 3 of the West Bengal Sugar Dealers Licensing Order 1980 within bracket herein after referred to as Order of 1980 and for violation of para 3 within bracket 2 of the West Bengal Declaration of Stock and Prices of Essential Commodities Order 1977 within bracket herein after referred to as the Order of 1977 and under section 8 of the West Bengal Anti-Profiteering Act 1958 or for contravention of paragraph 6 within bracket 2 of the said act and sentencing him to suffer rigorous imprisonment for 3 months and pay a fine of rupees 250 in default to suffer rigorous imprisonment for further 1 month on each count respectively, with further direction that both the sentences shall run concurrently. Para. The prosecution case as alleged against the appellant is to the effect that on 27/05/1988 at about 9:30 a.m. SI BB Vishwas PW DEO Bamungola along with other police officers and officers of food and supplies and weights and measures MALDA conducted a joint raid in the grocery shop of the appellant at Bulbul Chadi PS Habibpur and found huge quantity of sugar pulses and wheat products stored in the shop for sale. Appellant was present in the shop. The officers demanded to see license books of accounts in respect of the stock of the essential commodities. The appellant failed to produce any permit or license or books of accounts or any other paper. The officers also did not find any stock price board displayed at the shop showing stock and prices of the essential commodities stored. Accordingly, the police officer seized the stock of sugar weighing 16 quintals, pulses weighing 3 quintals, 50 kgs of wheat products under a seizure list in presence of local witnesses. Stop para. The appellant was arrested and a first information report was lodged for violating of paragraph 3 of Order of 1980 para 3 within bracket 2 of Order of 1977 punishable under section 7 within bracket 1 within bracket a within bracket II of the Essential Commodities Act 1955 and under section 6 within bracket 2 of the West Bengal Anti-Profiteering Act 1958 para. In conclusion of investigation, charge sheet was filed. Substance of accusation was read over to the appellant who pleaded not guilty and claimed to be tried. Para. In the course of trial, prosecution examined as many as 9 witnesses. The defense of the appellant was that the shop room was closed at the time of raid and the appellant was in his residence attending to his ailing wife who was suffering from cardiac ailments. At that time, 7 quintals of seized sugar belonged to one Nirapadu within the TW3 and had been stored in his shop due to rains, and accordingly there was no violation of paragraph 3 within bracket 2 of the Order of 1980. In order to probabilize his defense, he examined 3 witnesses and exhibited a number of documents. Para. Mr. Manna, learned advocate appearing for the appellant, submitted that PW1, an independent witness, has not supported the prosecution case. He submitted that the trial court allegedly ignored the evidence of DW3, who claimed ownership of 7 quintals of sugar seized in this case. He further submitted that the entire evidence on record does not establish the guilt of the appellant beyond reasonable doubt and the appellant is entitled to an order of acquittal. Para. On the other hand, Mr. Dutt, learned counsel for the state, submitted that the consistent version of the police witnesses was that the shop room was open and in spite of demand the appellant was unable to produce the books of account. There was no stock stock rate board, and no explanation was offered for the excess stock which was seized from the shop room. Accordingly, the appeal is liable to be dismissed. Therefore, I am of the opinion that the prosecution has not been able to prove its case of violation of paragraph 3 of the order of 1980 beyond reasonable doubt. Coming to the issue of non-production of books of accounts and stock rate board from the shop, it is the defense of the appellant that the shop was closed at the time of raid and he was at his house attending to his wife who was suffering from cardiac ailments. The defense was DW1 and DW4 both medical personnel to probabilize the ailment of his wife. In cross-examination, PW1 has also deposed that the shop was closed at the time of raid and the appellant had in fact offered to produce the books of accounts to the police officers when he was called to the shop. I am, however, unwilling to give credence to the evidence of PW1, who appears to speak in different tunes during his examination in chief and cross-examination. However, even if one documents the evidence of PW1, there is nothing on record to show that the members of the raiding party had issued requisition upon the appellant for production of the books of accounts and stock rate board at the time of raid. In view of the aforesaid inconsistencies in the prosecution evidence, the aforesaid lacuna assumes grave proportions and sounds a death knell for the prosecution case. Hence, I am inclined to extend the benefit of the doubt to the appellant with regard to violation of paragraph 3 within bracket 2 of order of 1977 and section 6 within bracket 2 of the Anti-Profiteering Act with regard to the allegation of non-maintenance of accounts and of required stock rate board in the shop room. In view of the aforesaid discussion, I set aside the judgment and order of conviction and sentence imposed upon the appellant. The appellant shall be discharged from his bail bonds after his 6 months in terms of section 437 ACRPC. Stop. The appeal is allowed. The copy of the judgment along with the LCR be sent down to the trial court at once for necessary compliance and for execution of the sentence as aforesaid. Urgent for certified copy of this order, if applied for, be supplied expeditiously after complying with all necessary legal formalities. Stop. Thank you.